Okay, I think we're ready to let people in if there are people waiting.
Hey, Brian, everyone from the waiting room has been admitted to the meeting. Maybe we wait a couple more minutes before we get started.
Okay, yeah, sounds good. Sorry, I just realized I have the wrong Zoom meeting address in this this sheet here in this on this PowerPoint slide. If everybody can look into the chat right now. Sorry. David, do we have addresses or links for people to access the Zoom meeting?
Yeah, hang on. Okay, it's in the Zoom chat.
Okay, great, thank you.
Okay, I don't see anyone else in the waiting room and no other email requests are coming in, so why don't we get started?
Okay. Let me just get set up here. Okay, aloha and good evening to everyone on the Zoom call and those listening in via YouTube. It is now 5:34 p.m. and this public hearing is called to order. Before we begin, please turn off your video and microphone while the presentation is given. You can turn both on when giving testimony. This is a formal public hearing on proposed amendments to Hawaii Administrative Rules 13-75, rules regulating the possession and use of certain fishing gear, HAR 13-60.4, West Hawaii Regional Fishery Management Area, Hawaii. The primary purpose of these amendments is to establish a required annual laynet permit and associated permit fee that would replace the existing one-time laynet registration. Other proposed amendments are being included to strengthen the enforceability of the laynet rules, to bring the rules into conformity with other laws, and to address other housekeeping matters. As required by law, rules have been drafted in Ramsar format, copies of which have been found on the DAR website, the link to which is included in the chat. My name is Brian Ishida, and I am an aquatic biologist with the Division of Aquatic Resources. I'll be conducting tonight's public hearing. Here to assist, should any questions regarding these amendments arise, our Fisheries Program Manager, David Sakota, and Legal Fellow, Kaylee Segum from the DAR Oahu office. On the call also are DAR staff members, Diana Lopera and Anita Sang, or assisting with the Zoom conference call and YouTube recording. The purpose of this hearing is to provide the public with the opportunity to provide comments in the form of oral and written testimony on these proposed amendments to the administrative rules regarding the possession and use of certain fishing gears. If there's anyone participating on this Zoom call who is not yet registered, please make us aware of your presence by adding your name in the chat at this time. Those wishing to provide oral testimony but have not pre-registered can request to do so in the chat now. When it's time to testify, I will call the names in the order in which they signed up. Background. DAR proposes to amend and compile HAR Chapters 13-75, Rules Regulating the Possession and Use of Certain Fishing Gear, and 13-60.4, West Hawaii Regional Fishery Management Area, Hawaii. The primary purpose of these amendments is to establish a new annual lay net permit requirement and fee for the use and possession of lay nets, and to remove the existing one-time lay net registration requirement. The current lay net registration, which requires lay net users to register each net individually, has been problematic in that it requires not only that every new net be registered, but also updated when sold, given away, destroyed, stolen, etc. Registrations aren't commonly updated, leaving DAR with an inaccurate estimate of lay nets currently being used in the state. Additionally, the current registration is non-revocable, meaning that a person convicted of a lay net violation cannot be prohibited from using them in the future. Lay net violations are commonly the #1 DAR-related investigation conducted by DOCARE officers each year. A revocable permit will act as a strong deterrent against repeat violators that, despite multiple infractions, continue to use lay nets illegally. Other proposed amendments are being included to strengthen the enforceability of the lay net rules, to bring the rules into conformity with other laws, and to address other housekeeping matters. The proposed amendments will be described individually in detail shortly. Approval to conduct this public hearing was obtained by the Board of Land and Natural Resources on December 10th, 2021. The legal notice of this public hearing was published in the February 13, 2022 Sunday issue of the Honolulu Star Advertiser. The hearing will be conducted as follows. I will explain the proposed changes to the administrative rules. Then I will call on those who have signed up to testify in the order in which they registered. Please keep your testimony brief and on subject in order to allow all those who came today the opportunity to testify. Each person providing testimony will be given 3 minutes. Please be aware that if you go beyond 3 minutes, I'll kindly ask you to conclude your testimony. After those who signed up have presented their testimonies, I will ask if anyone else wishes to testify. After all persons have given their testimonies and you wish to add to your testimony, you will be provided an additional 13 minutes. We are recording this hearing to make a written record, so please state your full name before giving your testimony. Make sure you speak clearly so we accurately record your testimony for the record. Now I'll go through a detailed description of each amendment. The proposed amendments are as follows. 1. Amend HAR 13-75-1 definitions to amend the definition of lay net to clarify that a lobster net is a type of lay net, and to add new definitions for freshwater stream, lobster net, multi-panel lay net, and throw net. The current rule defines a lay net as a gill net that is used in lay net fishing. This narrow definition has been construed to exclude lobster nets because lobsters do not get ensnared around their gills specifically. However, lobster nets pose entanglement hazards to marine life, including protected species such as sea turtles and monk seals, just as lay nets do. To reduce the unintentional and wasteful take of marine life, the department believes that lobster nets should be considered lay nets and regulated as such. Please note the passage of this particular proposed amendment would prohibit the use of lobster nets at night, as they would be subject to the current lay net rules. The department additionally has received inquiries about what constitutes a freshwater stream for the purpose of the lay net rule. The department has interpreted the existing rule to prohibit lay net fishing in any stream, canal, or other channelized body of freshwater through which freshwater flows or is designed to flow, regardless of the actual salinity of the water. We have also received inquiries regarding the definition of throw net and multi-panel lay net, so we propose to add definitions for clarity.
Hey, Brian, you're not sharing your PowerPoint presentation.
Okay. Technical difficulties. Let me reshare.
That looks good.
Okay. Okay, I think we're on 2, which is amend HAR 13-60.4-3 definitions to add a new definition for multi-panel laynet. This amendment will ensure that the definition of multi-panel laynet included in HAR 13-75-1 is mirrored in HAR 13-60.4-3. 3. Amend HAR 13-75-8 firearms to prohibit the take of sharks with firearms. The current rule includes a provision that allows the take of sharks with firearms in the state. The legislature recently passed Act 51, that prohibits intentionally or knowingly killing a shark in state marine waters. Act 51 took effect on January 1st, 2022. This is a housekeeping measure in that it removes an activity currently prohibited by law. 4. Amend HAR 13-75-12.2 akule nets to clarify that akule may be taken with legal throw nets. Currently, non-commercial fishers are prohibited from taking akule with any net, including throw nets, with a stretch mesh of less than 2 3/4 inches. The proposed amendment would allow the use of legal throw nets, which must have a stretched mesh of at least 2 inches to take akule. The department believes that this allowance would not result in adverse impacts to resources. 5. Amend HAR 13-75-12.4 laynets to establish a laynet permit requirement and fee for the use and possession of laynets, to remove the existing laynet registration requirement, and to prohibit leaving a laynet unattended for any amount of time. The legislature recently passed Act 45, which authorizes the department to adopt rules to require permits for the use and possession of laynets, including reasonable permit fees and provisions for revocation, suspension, and withholding of permits for noncompliance with laynet rules. The current laynet rule requires all laynets to be registered with the department. Registration is a one-time requirement. While the current rule requires laynet owners to report when a registered net is lost, destroyed, sold, traded, stolen, given away, or otherwise no longer the property of the registered owner, in practice, this is rarely reported and hard to enforce. As a result, the department does not have a good estimate of the number of laynets in use or the number of fishers actively using laynets each year. The proposed annual laynet permit would allow the department to track the number of permitted laynet fishers on a yearly basis, rather than by the number of registered nets that may or may not be used or even in existence. The proposed laynet permit would also encourage greater compliance with laynet regulations and help the department to crack down on their illegal use. Unlike a registration, a permit is revocable. Under the current rule, if a person has been convicted of a laynet violation, the department has no way of prohibiting them from registering and using a new laynet. Under the proposed rule, the laynet user could lose their permit if convicted of a violation, so there is a greater incentive to comply with the law. The department proposes charging a $25 permit fee and $10 duplicate permit fee to offset the costs of administering the laynet permit. Fees may be waived upon request for Hawaii residents eligible for benefits under the Supplemental Nutrition Assistance Program. Removing the laynet registration requirement would reduce the burden on laynet fishers and Division of Aquatic Resources staff. Under the current rule, fishers must contact DAR to register each laynet. DAR staff assigns a unique registration number to each laynet that is registered and enter it into a database. Under the proposed amendment, a fisher would only need to obtain a permit once per year, and they would be able to obtain and use multiple laynets under their permit. Rather than each net having a unique registration number, the proposed rule would require each laynet to be labeled with the fisher's laynet permit number. The current laynet rule allows fishers to leave a laynet unattended for up to 1/2 hour. This allowance makes enforcement difficult, as the doe care officer must observe an unattended laynet for 30 minutes before determining that a violation has occurred. Further, monk seals, turtles, and other marine life can be entangled and die during the 1/2 hour period of unattendance. Proposed rule requires a laynet to be attended for the entire time it is set, and clarifies that a laynet will be considered unattended if the laynet or surface buoys are not within eyesight of the person using the laynet. 6. Amend HAR 13-75-12 to clarify that it is unlawful for any person to leave a gill net unattended for any amount of time, and that the person using the gill net must visually inspect the net within 2 hours of deployment and must release any threatened, endangered, prohibited, or unwanted species. This amendment was added at the request of the Board of Land and Natural Resources to provide clarity regarding the legal use of gill nets. 7. Amend HAR chapters 13-75-12.5, State Waters around Moloka'i Special Rules, and 13-60.4-5, Activities Prohibited Within Selected Areas, and also Chapter 13-60.4-6, Laynet Permit and Use Requirements, to make conforming amendments to special laynet rules that apply to Moloka'i and West Hawai'i. The proposed amendments are necessary to implement the statewide laynet permit requirement and remove the existing statewide laynet registration requirement, but they will not change the unique place-based laynet regulations established for Moloka'i and West Hawai'i. 8. Amend chapters HAR chapters 13-75-2 penalty and 13-60.4-8 penalty to clarify the authorized penalties for violation of these chapters. And 9. Adopt HAR chapters 13-75-12.5 asset forfeiture and 13-60.4-8.5 asset forfeiture to provide notice of the state's authority to use civil asset forfeiture as an enforcement tool for violations of these chapters. These two amendments will facilitate enforcement of these chapters by providing the department with the appropriate range of tools to deter violations. Lastly, the amendments also intend to make other non-substantive amendments for formatting and style and compile HAR chapters 13-75 and 13-60.4. We will now begin the testimony portion of this hearing. As I call on you, please state your name, state clearly whether you support, oppose, or have no position on the proposed rules. I think first on the list is Inga Gibson.
Oh, sorry. Did you hear me?
No, sorry. Yeah, I think you were on mute.
Oh, okay. I was talking. Oh, I was just saying, this is Inga. I have a number of questions. Is there a question and answer period? Otherwise, I'm not sure how to incorporate my questions along with my public comments because it may run over 3 minutes.
So I see David put in the chat, no questions at this time, but you can include them in the testimony.
Okay, that's okay. Yeah, because obviously some of my questions, if they were answered, that would change my potential formal comment. So, okay. Well, I'm concerned about the report of bycatch in the gill and lay nets. there have been a number of cases, especially with baby mono that were captured in some lay nets, and what the reporting requirements are for bycatch. Also, you had mentioned that there's a requirement to release. Is that release endangered species only? And how would that be enforced regarding a requirement to release? I'm just wondering if it would potentially absolve someone of being charged if they're giving an opportunity to release. I'm also concerned. I understand the interest in improving the efficiency of the reporting system, but it's my understanding that you said that individuals are going to have one permit number, but they're not going to have to report the number of nets. So I'm just wondering how that would result in accurate data reporting, because if one person has a permit number, but you don't know if they have 1 net or 10 nets, it just seems, and again, it may be because I'm missing something. My next comment is regarding the Shark Protection Act. There was a clause that asked DAR to look at prohibiting gill and lay nets, specifically in mono pupping areas. I'm wondering, I didn't hear that mentioned, if that's going to be a separate process, or if there's any place-based consideration of any of these net regulations, because that is a concern. Absolutely support the additional restrictions on take of mono by a firearm. I know West Hawaii Regional Fisheries Management Area has, I believe, already prohibited that. So I guess I just wanted to clarify that obviously this provision now is going to be a statewide prohibition on take and explicitly stating take by a firearm. And then I also wanted to note our support for the civil asset forfeiture proceedings that are being added. I think that's absolutely necessary. And then my final 2 comments are, and I don't know how many other people may be testifying. On my end, it looks like I'm the only one, at least on Zoom, that has called in. That may not be the case, but I just know that there's been a lot of folks in the community that were not aware of this process, and there was no outreach to them. I did my best to try to let people know about this. So just DAR thinking about in the future their outreach to the community and various stakeholders in advance. I had actually communicated with DAR that there were some additional changes that we would have liked to see to these proposed rules, but was informed that obviously any changes or recommendations that are made outside the specific scope of what's being proposed would require an entirely new rule process. And I know you guys already have so much on your plate with pending rule processes. So just to consider more community outreach. And of course, as many of you may know, we are disappointed that none of these reflect some of the recent science regarding the importance of herbivores and restricting herbivores, whether it be with fishing gear or the issuance of permits, especially because we know that now it's really the abundance of herbivores versus the biomass. So those are my preliminary comments, and I will submit additional written comments maybe after I get some clarification on the questions I had. Mahalo.
Thank you for your testimony. I think that we don't have additional testimony lined up. If you would like additional 3 minutes, you can add on, Inga.
Oh, mahalo, Brian. I guess it would just, I don't have anything else right now to say, except that, we generally support what's proposed, but still have some questions. And again, more of comments regarding the process. Otherwise, that's it for now, and I'll submit subsequent written testimony if needed.
Thank you. So, DAR staff, is there anybody else signed up last minute?
Don't see anyone else in the waiting room. We don't have any other email requests to join last minute. So why don't we go ahead and continue?
Okay, thank you. Okay, so people unable to attend today or wishing to present additional comments may mail written testimony to us by April 1st, 2022, either by conventional mail or with written testimony through email. I think we sent to the addresses on the screen now. So as a supplement to this virtual public hearing, DAR will be holding additional in-person hearings on individual islands. Those specific dates have not yet been set. We plan to do so in the near future, and we encourage all interested parties to attend. After the public hearing process is completed, the following steps are taken, or will be taken. One, based on the testimonies presented, the Department will submit its findings and recommendations to the Board of Land and Natural Resources. Two, if approved by the board, the Department of the Attorney General will conduct a final legal review. If approved, the proposed rules will be given to the governor for his final approval. Three, should the governor grant approval, certified copies will be filed with the Lieutenant Governor's office, and after 10 days, it becomes effective as law. On behalf of the state of Hawaii, Department of Land and Natural Resources, I'd like to thank everyone for their time. It is now 5:57 p.m. and this public hearing is now adjourned. Mahalo.